Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In 1995, the Philippines took a significant step in addressing sexual harassment with the passage of Republic Act No. 7877, or the Anti-Sexual Harassment Act. At the time, it was a landmark law as it offered protection in workplaces, schools, and training environments where power dynamics were at play. Fast forward to 2019, or 24 years later, and much has changed. Society has evolved, and so did the forms and spaces where harassment took place. Harassment acts increasingly occurred not only on the streets and public transportation, but also across the vast digital world. It was in 2019 when Republic Act No. 11313, or the Safe Spaces Act, was signed into law. RA 11313 broadened the scope of protection in areas beyond the traditional settings like work and school to include public areas, online platforms, and even daily commutes. It also widened the scope of accountability, holding not just those in authority responsible, but anyone who engages in gender-based harassment. What are the key differences between RA 7877, or the Anti-Sexual Harassment Act, and RA 11313, or the Safe Spaces Act, in how harassment is defined and who are protected? How do these laws vary in terms of accountability, legal remedies, and scope? Hi, I'm Atty. Mike Navallo, Supreme Court Chief Communications Officer. It's the 8th of August 2025, and today we talk about RA 7877, the Anti-Sexual Harassment Act, vis-à-vis RA 11313, or the Safe Spaces Act. We'll try to know their key differences in how harassment is defined and who is protected. Likewise, how do these laws vary in terms of accountability, legal remedies, and scope? And joining us to talk about RA 7877 and RA 11313 is Judge Bernard P. Bernal, Professorial Lecturer of the Philippine Judicial Academy. Hi, Judge Bernal. Thank you again for joining us and welcome back to the Supreme Court Podcast.
Hello, Attorney Mike. Thank you for having me again here.
Good to see you again, Judge. Now, in last week's podcast episode, we discussed the case of Anna, not her real name, a customer associate hired by LBC Express in Cebu who was sexually harassed by her male supervisor that prompted her to resign. Now, for the benefit of our listeners, Judge, what is RA 7877, or the Anti-Sexual Harassment Act? When did it take effect?
Attorney Mike, RA number 7877, or the Anti-Sexual Harassment Act of 1995, is the first Philippine law that specifically addressed sexual harassment in the workplace, school, and training environment. This law took effect on March 5, 1995. As declaration of state policy, the law provides that the state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful.
That's RA 7877. And what about RA 11313, or the Safe Spaces Act?
RA 11313, or the Safe Spaces Act, which is commonly known as Bawal ang Bastos Law, is a landmark Philippine legislation designed to prevent and penalize gender-based sexual harassment in a wide range of settings. It took effect on 3 August of 2019. As state policy, it provides that it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. As provided by this law, it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that both men and women must have equality, security, and safety, not only in private but also on the streets, public spaces, online, workplaces, and educational and training institutions.
Judge, I note that both laws actually protect against sexual harassment, but why was there a need to legislate the Safe Spaces Act if you already have the Anti-Sexual Harassment Act?
The Safe Spaces Act was enacted to fill in the gaps left by RA 7877 or the Sexual Harassment Act. The main limitations of RA 7877 became apparent over time, which prompted Congress to provide broader legislation, such as the Safe Spaces Act. The key gaps include that RA 7877 requires power imbalance. What do we mean by this? The law only applies if the harasser has authority, influence, or moral ascendancy over the victim. Also, RA 7877 has limited coverage. The sexual harassment applies only in workplaces, educational or training institutions, and does not cover those committed in public places, online spaces, or transportation. RA 7877 also provides outdated enforcement mechanisms because it lacks clear procedure for institutional accountability, such as mandatory policies or support systems for the victim. It only focuses on administrative action with limited criminal sanction. Lastly, it was likewise seen as a gap that RA 7877 does not address gender-based harassment, since it provides narrow view of harassment and does not fully protect the victims from street harassment, stalking, catcalling, and online abuses.
And just to distinguish both laws, Judge, what are the most significant differences between the two laws in terms of coverage and definition of harassment?
Under RA 7877, sexual harassment has been defined as a demand, request, or condition for sexual favor made by a person in authority or influence over another in a work, education, or training environment. And it focuses on a hierarchical power relationship such as boss-subordinate or teacher-student. With respect to RA 11313, it expanded the definition of harassment to include any unwarranted and uninvited sexual actions or remarks against any person regardless of the motive for committing such action or remarks. This includes catcalling, stalking, cyber harassment, and more, whether or not there is a power imbalance. Likewise, it covers gender-based sexual harassment in public places, workplaces, schools, and online. With respect to coverage, RA 7877 is limited to workplaces, schools, and training, while RA 11313 expanded sexual harassment to be committed in public spaces, online, workplace, and school. As to persons who can be held liable, RA 7877 is limited to those who are in authority, while RA 11313 pertains to anyone, even strangers, peers, or subordinates can be made liable for violating this law. Harassments under 7877 is limited to power-based sexual favors, while RA 11313 harassment includes catcalling, leering, stalking, online threats, and the like.
And Judge, who is protected under RA 11313 that are not covered under RA 7877?
Considering that RA 11313 expanded the coverage of sexual harassment, it must be emphasized that everyone in public spaces are protected. This would include commuters, pedestrians, shoppers. Also, there is no need for a superior-subordinate relationship since peer-to-peer harassment is likewise covered by 11313. With the advancement of technology, victims of online and cyber harassment is likewise covered by this law. Notably, men and members of the LGBTQ plus community are likewise covered by 11313 since it is not only limited to women in the workplace or schools.
And what about those who can be held accountable under RA 11313? Who are those that which were not covered under RA 7877?
As I mentioned earlier, this law is groundbreaking because strangers and bystanders who commit street or public harassment can be held accountable for violating this law. Acts that we used to consider as harmless may now be considered as a violation of the Safe Spaces Act. Co-workers or peers, not just those in authority, can be held liable. Online harassers, which includes stalkers or those who sends you lewd messages or share non-consensual content, It also provides that establishment and employers can be held liable if they fail to prevent or respond to the incidents.
Mhm. Judge, in establishing a violation under RA 11313 or the Safe Spaces Act, is there a requirement that there should be a relationship similar to that under RA 7877 or the Sexual Harassment Act?
With respect to the Safe Spaces Act, there is no relationship required in order to commit a violation of the law. It protects any person from gender based harassment, regardless of relationship.
Mhm. And in terms of the acts, what needs to be proven to secure a conviction, first under RA 7877 and secondly under RA 11313?
To constitute a violation of RA 7877, the following items must be proven. First, that there is an authority relationship between the offender and the offended party, such as a boss and a subordinate, a teacher and a student. Second, there is an unwanted sexual advance or conduct perpetrated by the offender, which may be verbal, physical, or visual. And lastly, hostile environment. The act is used as a condition for employment, promotion, grades, or create an intimidating or offensive environment for the victim. To constitute a violation of RA 11313 or the Safe Spaces Act, the following must be proven. First is the unwanted gender based behavior. This would pertain to catcalling, stalking, lewd gestures, cyber stalking, sexual jokes, and groping. Second is the occurrence in a covered setting, such as a public space, workplace, school, or online. Lastly, the effect on the victim must be proven if the behavior caused fear, discomfort, or humiliation on the part of the victim.
Mhm. And Judge, are there differences in terms of the penalties imposed by each law?
Yes, Attorney Mike, there are key differences in penalties between RA 7877 and RA 11313, both in scope and severity. In RA 7877, imprisonment is not less than 1 month nor more than 6 months, or the fine should not be less than 10,000 nor more than 20, or both depending on the court's discretion. Also, administrative sanctions may apply, such as suspension or dismissal from work, especially if the sexual harassment took place in a work setting or in a school setting. On the other hand, under RA 11313 or the Safe Spaces Act, the penalty would really vary depending on the act or the number of the offenses, and they provide stricter and more detailed penalties.
And what do you mean by that, Judge? For example, what kind of acts would merit a lower penalty under the Safe Spaces Act, and what would merit the highest penalty under the same law?
In cases such as catcalling, wolf whistling, or sexual jokes, yung mga jokes na ang ganda mo naman ma'am, pwede ba kitang anakan, that is offensive to the victim, this can merit a fine of 1,000 pesos, community service, and attendance to gender sensitivity seminars if committed for the first time. Yan yung pinakamababa in terms of penalties.
Mhm. And what about the harshest penalty? Saan siya ini-impose?
As for the highest penalty, this would pertain to acts of stalking and such other acts that would violate the Safe Spaces Act when accompanied by touching private parts or parts of the body of the victim. The third offense would merit you 100,000 fine plus imprisonment of arresto mayor in its maximum period.
Mhm. Or that's about 6 months.
6
maximum
months.
6 months.
Yes, 6 months, just like the one imposed in Sexual Harassment Act.
And of course, for both laws, you can also ask for moral damages, exemplary damages, nominal damages, and attorney's fees, right?
Yes, apart from the criminal reliefs that may be sought by the victim, civil reliefs such as those you mentioned are likewise available.
Mhm. And Judge, RA 11313 broadened the scope of protection to cover public spaces, online or digital spaces, and transportation. How does the Safe Spaces Act define these areas, and how crucial is this development in keeping up with the evolving nature of harassment today?
The law was very clear in the definition of public spaces. It would refer to streets and alleys, public parks, schools, buildings, malls, bars, restaurants, transportation, terminal public markets, spaces used as evacuation center, government offices, public utility vehicles, as well as Notably, private vehicles covered by an app-based transport, network services, and other recreational spaces such as, but not limited to, cinemas, theaters, and spas. As for online digital spaces, referring to gender-based online sexual harassment, this would refer to acts committed through information and communication technology that cause or likely cause mental, emotional, or psychological distress. An example of this would be when you upload a photo or you share a video of a person in any of your social media platforms without the consent of the person that you posted. Lastly, public utility vehicles and transportation would include jeepneys, taxi, tricycle, and app-based transport network vehicle services such as Grab, where the perpetrator is the driver of the victim and the offended party is the passenger.
So it's considered PUV if it's between the driver and the passenger. But it
Yes.
could also be considered a public space if the perpetrators were otherwise, like maybe a co-passenger.
Yes, it can apply. Even if it is committed inside a POV, there can be sexual harassment under RA 11313.
And how significant is this development, Judge, that even online spaces is already considered covered by RA 11313?
This is very important because it is a recognition on the modern forms of sexual harassment. RA 11313 acknowledges that harassment has evolved beyond the traditional workplace or school setting, especially with the rise of social media and digital communication. It addresses the gap that was earlier created by laws such as 7877, which was limited to authority-driven harassment. It likewise expanded protection to vulnerable sectors of society, not only limited to women, but all persons, regardless of their gender, from harassment in everyday public interaction, going to work, coming home from work, browsing online. This is vital in a highly urbanized and digital connected society like the Philippines, where public and virtual spaces overlap constantly. Likewise, by specifically defining punishable acts in public and online setting, the law creates accountability for behaviors previously dismissed as trivial. Those that we considered normal before, such as catcalling, wolf whistling, these are no longer acceptable under the Safe Spaces Act. Victims can now seek redress without needing to prove a power imbalance, which is not present under RA 7877. This makes the law more inclusive and survivor-centered and responsive to the real-world experiences that we have now.
But does RA 11313, Judge, abandon or effectively replace RA 7877, or do both laws still apply under different contexts?
No, RA 11313 does not abandon or effectively replace RA 7877. Both law applies under different contexts. Under RA 11313 or the Safe Spaces Act, the same generally applies to gender-based harassments in streets, public places, online, workplace, and educational institution. It expands the definition of sexual harassment. Meanwhile, RA 7877, or otherwise known as the Anti-Sexual Harassment Act, covers sexual harassment in an employment, education, and training institution. Here, there must be a moral ascendancy committed by the perpetrator against the victim. Note, however, that in workplace setting, RA 11313 can still be applied provided that there is a gender-based harassment that took place.
So theoretically, can both laws apply at the same time?
Yes, I believe that both laws can be applied simultaneously, but they operate in different scopes depending on the circumstances of each case.
Judge, what advice would you give to people who think they have experienced harassment but are not sure which law, if any, protects them?
I would tell these victims to not remain silent. RA 11313 and RA 7877 are there to uphold and protect their rights and for them not to feel afraid in coming out in addressing the issue of sexual harassment. Gone are the days wherein victims need to suffer in silence because no one is there to listen or the situation or the environment for them is hostile. These laws, and with the help of the Supreme Court through the decisions they render, provides employees or victims of sexual harassment an opportunity to speak up, so that their stories may be heard and that the people who committed the offense may be held accountable.
And finally, Judge, to close our discussion, what would be our key takeaway from this distinction between sexual harassment and the Safe Spaces Act?
That would be to advise everyone to know their rights under the pertinent provisions of RA 11313 and RA 7877 on sexual harassment. I believe that we should treat one another with respect and kindness, regardless of our sexual preference, gender, race, or ethnical group, and foster an environment that sexual harassment should not survive or thrive at this age and time.
All right. Thank you very much, Judge Bernal, for again joining us on the SC podcast.
My pleasure, Attorney Mike, and thank you for having me here again.
All right. And to our listeners, if you wish to read more about the Anti-Sexual Harassment Act and the Safe Spaces Act, please visit the Gender Corner of the Supreme Court website, sc.judiciary.gov.ph. Here's Steph Atendido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. New Sharia counselors at law on Wednesday, August 6, 2025, took their oath and signed the roll in Manila after successfully passing the 2025 Sharia Special Bar examinations. SC Clerk of Court on Bank Attorney Marife M. Lumibao Cuevas administered the oath to more than 150 new Sharia counselors at law. 2025 SSBE Chairperson Associate Justice Antonio Co. Jr. and 2026 SSBE Chairperson Associate Justice Henry John Paul Inting delivered messages to the newly admitted Sharia counselors at law. A total of 154 out of 629 examinees, or 24.48%, passed the 2025 SSBE conducted on May 25 and 28, 2025. The Supreme Court on Tuesday required Vice President Sara Duterte and Attorney Israelito Torreon and their co-petitioners to comment within 10 days on the motion for reconsideration filed by the House of Representatives on the decision declaring unconstitutional the impeachment complaint against the Vice President. The Supreme Court also noted the motion for reconsideration filed by Representative Percival V. Sandanya et al. Pending the court's action on their motion for intervention. During the same session, the Supreme Court ordered Presidential Advisor for Poverty Alleviation, Lorenzo Gadon, Representative Percival Sandanya, and Richard Haydarian to comment within 10 days on the petitions for indirect contempt against them. The petitions were filed in relation to the remarks against the Supreme Court decision declaring the articles of impeachment against Vice President Duterte unconstitutional. The Supreme Court invalidated the sale of 2 parcels of land because the buyer knew that the seller was not the real owner. In a decision written by Associate Justice Maria Filomena Singh, the SC's 3rd Division canceled the sale made by Bayani S. Cerilla to Edward C. Quiacho. The SC found that Quiacho knew the sold properties did not belong to Cerilla since there was no real intention to transfer ownership from the original owner to Cerilla. Even after the land titles were transferred under his name, Cerilla did not act as if he owned the lands. Under the Civil Code, for a sale to be valid, the parties must agree to the sale. The parties' actions during and after the agreement can serve as basis to determine their intent. The seller must also be the owner of the property or has authority to sell. In another case, the Supreme Court has clarified that businesses registered with the Philippine Economic Zone Authority, or PEZA, are not completely exempt from paying value-added tax, or VAT. The SC's 3rd Division, through Associate Justice Chapar de Maampao, partially granted Coral Bay Nickel Corporation's claim for a VAT refund. The SC held that if goods are used outside the eco zone, but still within the Philippines, the destination principle will apply. This provides that goods are taxed in the country where they are consumed. In Coral Bay's case, the purchases were consumed outside the eco zone, but within Philippine territory. As they are subject to VAT, Coral Bay is entitled to a refund for the unutilized input VAT. Meanwhile, on Tuesday, the Office of the Bar Confidant issued a notice regarding the extension of the deadline for completion of the mandatory first assessment or asynchronous exam for the 2025 bar examinations. The 2025 bar exams will be held on September 7, 10, and 14, 2025 at 14 local testing centers across the country. You are now up to date with the Philippine Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Atty. Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Lauren Solanio, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.